government a medical malpractice regime and a medical licensing regime such that effectively all state medical malpractice laws, all state medical licensing laws would be preempted.
And you're imagining that this is regulatory action or that Congress has passed a statute creating kind of a federal malpractice regime?
You call it.
I mean, I think I have a broad view of Congress's authority to enact statutes, and so what I'd want to assess in that situation is, whether Congress is acting pursuant to one of its enumerated powers.
Spending clause. It was all spending clause.
Yeah, so I think that very likely Congress could make those kinds of judgments and attach conditions to the receipt of federal funds. And, in Medicare, there are substantial conditions.
All hospitals in the state and effectively transforms the regulation of medicine into a federal function.
There might be a point at which this court thinks that it's really encroaching on the state's prerogatives in ways that are inconsistent with our constitutional structure, but I don't think we're anywhere close to that in this case.
But do you see any bounds just in principle?
I think the bounds, would have to come from this court's case law concerning federalism principles. The court has said in cases like Gonzalez versus Oregon that, of course, the federal government has authority to comprehensively regulate on health and safety, including with respect to medical care. And so I don't think that there's any principle of exclusive governance of this area by the state. But obviously, I'm sure you could construct hypotheticals that really seem to be the federal government entirely taking over a state function, and maybe that would be subject to a different principle.
Yeah. EMTALA and Medicare allow the federal government to enforce the EMTALA dictate through civil monetary penalties?
That's correct, yes.
And also you can terminate the Medicare agreements if a hospital violates EMTALA, in your view?
Yes, generally the hospital is given the opportunity to come into compliance and to develop a plan to ensure that there won't be future EMTALA violations. It would obviously be an extreme sanction to terminate Medicare funding, but that is a possibility.
And there's also a private right of action for EMTALA violations that have the possibility of equitable relief as well.
Yes, certainly monetary relief and possibly equitable relief as well.
In this case, you brought an equitable cause of action. You didn't cite any statute to enforce EMTALA. And one of the rules in equity, traditionally at least, is that you don't get an equitable relief if there's an adequate remedy at law. And as we just discussed, there's a pretty reticulated statute here. Seminole Tribe says when you have a reticulated statute and lots of remedial options, you don't get equitable relief. Thoughts?
So let me say at the outset that the United States has long been recognized to have an action in equity, an inherent action in equity to appeal to the courts of this nation to protect its sovereign interests.
It's
and
sovereign,
that's been reflected in things like
interests. You mentioned Washington and you mentioned
Arizona versus the United States is another example of that.
Arizona was, just sorry to interrupt, but Arizona was an immigration case and border, and Washington was an attempt by a state to impose its worker compensation laws on the federal government in a way different from others. I take those points, and equity is all about proprietary interests and things like that. Do we have that here?
Well, I think that the court, it's not, I want to make sure to make clear that there are a long line of cases that stand for this principle, including cases that have addressed it directly, like In re Debs, Wyandotte.
Do you really want to rely on Debs, General? I mean, that wasn't exactly our brightest moment.
I do think, though, that it reflects the history and tradition of this nation in recognizing that it's entirely appropriate for the United States to seek to protect its interests in this manner. And let me say, Justice Gorsuch, this is a really important issue to the United States. It wasn't pressed below. It wasn't passed upon. We haven't briefed it at all. It's not jurisdictional.
I'm just trying to understand where it comes from. What is the proprietary interest here?
It comes from...
to me it's your money and how it's being spent, and Congress has given you lots of tools.
I think it also comes from the recognition under obstacle preemption principles that there are important functions to be served by having the Medicare program in place, and Idaho has directly interfered with the ability of hospitals to accept these federal funds when they stand willing and able to comply with EMTALA's mandates and fulfill Congress's desire here to make sure that no matter where you are in this country, if you have an urgent medical need and you go to an ER, you can be stabilized.
Thank you.
General,
Counsel, your friend on the other side said that your position would require
religiously affiliated hospitals with emergency rooms to perform abortions. Was he right?
No, my friend was wrong. There are federal conscience protections that apply at the entity level to hospitals as well. The key provisions are in the Weldon Amendment and also Coate Snow, although that depends on the residency program of a particular hospital. Now, HHS said in a 2008 rulemaking on conscience protections that it had never come across a hospital that had a blanket objection to providing life-preserving and health-preserving pregnancy termination care. But if a hospital had that kind of objection, and HHS recently informed me they still have not come across that hospital, that would be honored vis-a-vis HHS's enforcement ability.
You said that applies at the entity level. Can individual doctors in the emergency room, do they have a conscience exemption?
Oh, yes, yes. They're protected under the Church Amendments principally. And our position is that EMTALA does not override either set of conscience protections. So if an individual doctor has a conscience objection to providing pregnancy termination, EMTALA itself imposes obligations at the entity level, and the hospital should have plans in place to honor the individual doctor's conscience objection while ensuring appropriate staffing for emergency care.
Does that mean that there must be somebody in the emergency room that can provide an abortion? What if there are 2 doctors, 3 doctors, and they all have a conscience exemption?
No, in that circumstance, EMTALA could not override those individual doctors' conscience protections, but my understanding is that as a matter of best practice, because hospitals want to be able to provide emergency care, they do things like ask doctors to articulate their objections in advance so that that can be taken into account in making staffing decisions and who's on call. Hospitals have a lot of plans in place for these kinds of contingencies.
Yeah. Are you saying that there must be somebody available and on call in a hospital of that sort?
The conditions of participation for Medicare require hospitals to be appropriately staffed to provide emergency treatment. Now, in a situation where a hospital hasn't done that and it doesn't have anyone on hand who can provide care, maybe all of the doctors called in sick that day and there's just literally no one in the emergency room, or in this case, if everyone had a conscience objection, then the hospital would not be able to provide the care. But there are conditions of participation that are meant to ensure that there is good governance of hospitals and organization to account for these situations.
And the consequence of them not being able to provide the care would be what?
In that circumstance, I think they would likely be out of compliance with the conditions of participation that require them to be appropriately staffed. But if the question is, could you force an individual doctor to step in then over a conscience objection, the answer is no, and I want to be really clear about that. We don't understand EMTALA to displace it.
Excuse me. The question is whether or not they must have available someone who can comply the procedures required by EMTALA. And what would be the consequence if they didn't? Would it be eventual termination of their participation in Medicare?
That's right. So if a hospital was continually disobeying the requirement to have in place sufficient personnel to run their emergency room, then I imagine that HHS would, through enforcement action, work with that hospital to try to bring it into compliance. And if the hospital ultimately is just leaving itself in a position where it can never provide care, then it would terminate the Medicare funding agreement.
I thought you just said a minute ago, I'm sorry.
Oh, no, go ahead.
I just want to clarify this colloquy. I thought you said a minute ago, though, if the hospital had a conscience objection and therefore didn't provide certain care, that wouldn't render it out of compliance. Which is it?
That's correct. So the hospital could assert a conscience objection, and EMTALA would not override that.
My question, I have a question about the Hyde Amendment. So I gather from the briefing that there might be some situations in which EMTALA would require an abortion, but the Hyde Amendment wouldn't permit federal funds to be used to pay for it. And you said in your brief that EMTALA requires in other circumstances as well stabilizing treatment to be given that federal funds don't cover. Can you give an example of that? And am I right about the Hyde Amendment? And then can you give an example of that?
Yes, so you are right about both things. It is common under EMTALA that hospitals are going to have to provide care where there's not federal funding available. And I'll give you an example of a Medicare patient who goes in and his emergency medical condition means he needs a particular drug that's not covered by Medicare benefits. Still, the hospital has to provide him with stabilizing treatment and give him that medication, even though the federal funding isn't going to pay for it. And that also applies to people who are uninsured, who aren't covered by Medicare in the first instance. The whole point of EMTALA was it doesn't matter your circumstances, it doesn't matter whether you can pay or not, it doesn't matter the particulars of your situation. This is a guarantee. You can get stabilizing treatment. I want to say, though, that I don't think there's any inconsistency between the lines Congress drew in EMTALA and Hyde. And Congress itself has recognized that these statutes address discrete issues. I'm thinking here of the provision in the Affordable Care Act that was exclusively about abortion, and there Congress said Nothing in the ACA displaces Hyde and the other federal funding restrictions on abortion, but also nothing in the ACA displaces EMTALA's requirement to stabilize. And that shows two things. It shows first that Congress recognized that stabilizing care can sometimes be pregnancy termination, and I think it also showed Congress's recognition that these statutes address their own distinct spheres. And one final point on Hyde, Justice Barrett. My friend isn't drawing a line based on Hyde either, because his point is even if a woman is on the brink of death and she goes to an emergency room and there are federal funds available under Hyde to treat her, still hospitals have no obligation under EMTALA to provide that care.
So what about the colloquy I was having with your friend about what stabilizing treatment entails? Let's imagine a situation in which a woman is, 10 weeks, and is told that if you carry this pregnancy to term, it could have, consequences for your health, but you just would need to abort but before, like, say, 15 weeks, something like that. So there's not an immediacy, so she's stable when she leaves the hospital. But in Idaho, there's no place else that she can go, at least until she's 15 weeks. What is the federal government's position then?
I think, if I'm understanding the hypothetical correctly, that she likely wouldn't have an emergency medical condition in the first place, because the definition of having an emergency medical condition is that without immediate treatment, you will reasonably be expected to have serious dysfunction of your organs or serious impairment of your bodily functions. And so in that situation where a woman is somewhat high risk, maybe she has certain complications where doctors can say there's some danger with continuing this pregnancy, I don't think that creates the kind of emergency medical condition that EMTALA is aimed at.
Okay, last question, and this is about the spending clause issue. So it does seem odd, and I think kind of what some of the questions are getting at, it does seem odd that through a side agreement between a private entity and the federal government, the private entity can get out of state law, right? So in another administration, would it be possible then, in reliance on the spending power, for Congress to say, any hospital that takes these funds cannot perform abortions, or any hospital, despite state law requiring, a state constitutional amendment requiring abortion to be available? Is that possible? Or, with gender reassignment surgery? I mean, you can imagine it kind of going back and forth through spending clause litigation in ways that would be unusual.
Yes, I think Congress has broad power under the spending clause to attach conditions. Now, it doesn't mean that it's wholly unlimited. Obviously, Congress would be having to act pursuant to an enumerated power. It would have to comply with other constitutional limits, and so the law would have to be valid. The spending clause itself has built-in limits, things like relatedness and
so it would
notice.
Have to be acting pursuant to an enumerated power in forbidding gender reassignment surgery or abortion or those sorts of things?
No, I just meant that it would have to be valid. The spending clause itself would be enough, yes. So we think the spending clause itself would be enough.
Just to follow up on that, and going back to where I started with could the federal government essentially regulate the practice of medicine in the states through the spending clause? The answer, I think, is yes. Congress could prohibit gender reassignment surgeries across the nation. It could ban abortion across the nation through the use of its spending clause authority, right?
Congress does have broad authority under the spending clause, and yes, if it satisfies the conditions that the spending clause itself requires, then I think that would be valid legislation, and the court has in many contexts recognized the spending clause legislation preempts.
The answer is yes. Okay. So how do we reconcile that with the statement in 1395 that nothing in this subchapter allows a federal officer to exercise any control over the practice of medicine?
So at the outset, I think if Congress itself is doing it, then that provision is inapplicable by its own terms. That's looking at
Don't think it informs our view and understanding of the statute in any way?
Well, I think in the event of some kind of direct conflict, looking at EMTALA in particular, it's the later in time enacted statute, and it's clearly more specific, so it would control. But this court itself has rejected the idea that there would be that kind of conflict, and I'm thinking of the CMS vaccine case, where the litigants relied on this exact same provision of the Medicare Act, Section 1395, and this court said, no, that can't bear the weight that those litigants would place on it, or it would call into question all of the conditions of participation in Medicare.
Do you agree that our clear statement rule with respect to spending clause legislation, our clear statement rule with respect to federalism are in play here?
I think that here Congress has spoken clearly with respect to what providers are supposed to do.
That's not the question. Do you think those presumptions apply? Forget about whether you can satisfy them.
The requirement of clear notice under spending clause legislation, yes, I think that does apply, and providers have always understood their obligations under EMTALA.
General, let me ask you to respond to a couple of things Petitioner's counsel said and just give you the opportunity to respond. He suggested or said that you haven't identified a circumstance in which something that EMTALA requires Idaho wouldn't allow. And I didn't get a chance to ask him, but I took him to sort of mean that the way that Idaho statute operates, it basically allows for a doctor to say, well, in my view, this health-threatening circumstance could eventually lead to death, and so I'm going to do it. So to the extent that doctors are still able to do that, I guess he's saying there's no preemption. But is it true that there really isn't in operation a difference between the EMTALA and what Idaho has required here?
No, that is gravely mistaken on 3 levels. It's inconsistent with the actual text of the Idaho law, it's inconsistent with medical reality, and it's inconsistent with what's happening on the ground. And this is a really important point, so let me try to unpack this. On the text itself, Idaho's law only allows termination if it's necessary to prevent death, and that is textually very narrow compared to what EMTALA requires, with the category of harm to begin with. In Idaho, doctors have to shut their eyes to everything except death, whereas under EMTALA, you're supposed to be thinking about things like, is she about to lose her fertility? Is her uterus going to become incredibly scarred because of the bleeding? Is she about to undergo the possibility of kidney failure? So I think that is one critical distinction. The other critical textual distinction is the idea of necessity. Under Idaho law, you have to conclude that death will necessarily result, which is also materially different, and the Idaho Supreme Court specifically recognized it. Second, with respect to the actual medical reality here, there are numerous conditions that we are worried about where a doctor's immediate concern is not death. That's a far more remote possibility. They're thinking about the health circumstances that EMTALA guards against. And let me give you 2 examples. The first is PPROM, premature rupture of the membranes. We have declarations at 594 that explain this in detail, and also at JA 615 to 617. What the doctors explain there, this is Dr. Fleischer and Dr. Cooper, is a woman comes in with PPROM, her sac is ruptured, there's no chance the fetus is going to be able to survive, but at that point she doesn't have active signs of infection, and so until she deteriorates, you can't think she's close to death. What you're worried about is she will become infected, she might develop sepsis, she might have these dramatic consequences for her future, but it's not about death. So I think that is one example where you can't do it. And then finally, just the actual practice on the ground. Women in Idaho today are not getting treatment. They are getting airlifted out of the state to Salt Lake City and to neighboring states where there are health exceptions in their laws because the doctors are facing mandatory minimum, 2 years in prison, loss of their license, criminal prosecution. The doctors can't provide the care because until they can conclude that a prosecutor looking over their shoulder won't second guess that maybe it wasn't really necessary to prevent death.
Thank you, counsel. Justice Thomas? Justice Alito?
We've now heard, let's see, an hour and a half of argument on this case, and one potentially very important phrase in EMTALA has hardly been mentioned. Maybe it hasn't even been mentioned at all, and that is EMTALA's reference to the woman's quote-unquote unborn child. Isn't that an odd phrase to put in a statute that imposes a mandate to perform abortions? Have you ever seen an abortion statute that uses the phrase unborn child?
It's not an odd phrase when you look at what Congress was doing in 1989. There were well-publicized cases where women were experiencing conditions, their own health and life were not in danger, but the fetus was in grave distress and hospitals weren't treating them.
Well,
so what Congress did is that
have you seen abortion statutes that use the phrase unborn child? Doesn't that tell us something?
It tells us that Congress wanted to expand the protection for pregnant women so that they could get the same duties to screen and stabilize when they have a condition that's threatening the health and well-being of the unborn child. But what it doesn't suggest is that Congress simultaneously displaced the independent pre-existing obligation to treat a woman who herself is facing grave life and health consequences.
Well, let's walk through the provisions of the statute that are relevant to this issue regarding the status and the potential interests of an unborn child. Under B1, if a woman goes to a hospital with an emergency medical condition, that's the phrase, The hospital must either stabilize the condition or, under some circumstances, transfer the woman to another facility. So we have this phrase emergency medical condition in that provision, and then under E1, the term emergency medical condition is defined to include a condition that places the health of the woman's unborn child in serious jeopardy. So in that situation, the hospital must stabilize the threat to the unborn child. And it seems that the plain meaning is that the hospital must try to eliminate any immediate threat to the child. But performing an abortion is antithetical to that duty.
But in a circumstance...
You go so far as to say that the statute is clear in your favor. I don't know how you can say that in light of those provisions that I've just read to you.
The statute did nothing to displace the woman herself as an individual with an emergency medical condition when her life is in danger, when her health is in danger. That stabilization obligation equally runs to her and makes clear that the hospital has to give her necessary stabilizing treatment. And in many of the cases you're thinking about, there is no possible way to stabilize the unborn child because the fetus is sufficiently before viability that it's inevitable that the pregnancy is going to be lost. But Idaho would deny women treatment in that circumstance, even though it's senseless.
Doesn't what I've read to you show that the statute imposes on the hospital a duty to the woman, certainly, and also a duty to the child? And it doesn't tell the hospital how it is to adjudicate conflicts between those interests, and it leaves that to state law. Now, maybe most of your argument today has been dedicated to the proposition that the Idaho law is a bad law, and that may well be the case. But what you're asking us to do is to construe this statute that was enacted back during the Reagan administration and signed by President Reagan to mean that there's an obligation under certain circumstances to perform an abortion, even if doing that is a violation of state law.
If Congress had wanted to displace protections for pregnant women who are in danger of losing their own lives or their health, then it could have redefined the statute so that the fetus itself is an individual with an emergency medical condition. But that's not how Congress structured this. Instead, it put the protection in to expand protection for the pregnant woman. The duties still run to her. And in a situation where her own life and health is gravely endangered, then in that situation, EMTALA is clear. It says the hospital has to offer her stabilizing treatment. And she doesn't have to accept it. These are tragic circumstances, and many women want to do whatever they can to save that pregnancy, but the statute protects her and gives her that choice.
The only way you try to get out of the statutory interpretation that I just posited is by focusing on the term individual. And you say, aha, in the Dictionary Act, individual is defined to exclude an unborn child or a fetus. That's the only way you can try to get out of what I've just outlined. And isn't it true that under the Dictionary Act definitions apply only if they are not inconsistent with the statutory text? And when you have a text that certainly you wouldn't dispute the fact that the hospital has a duty to the unborn child where the woman wants to have the pregnancy go to term, it's indisputably protects the interests of the unborn child. So it's inconsistent with the definition in the Dictionary Act.
No, not at all. The duty runs to the individual with the emergency medical condition. The statute makes clear that's the pregnant woman. And of course, Congress wanted to be able to protect her in situations where she's suffering some kind of emergency and her own health isn't at risk, but the fetus might die. That includes common things like a prolapse of the umbilical cord into the cervix where the fetus is in grave distress, but the woman is not at all affected. Hospitals otherwise wouldn't have an obligation to treat her, and Congress wanted to fix that. But to suggest that in doing so, Congress suggested that the woman herself isn't an individual, that she doesn't deserve stabilization, I think that is an erroneous reading of this statute.
Nobody's suggesting that the woman is not an individual when she doesn't deserve stabilization.
Well, I think the premise of the question would be that the state of Idaho can declare that she cannot get the stabilizing treatment even if she's about to die. That is their theory of this case and this statute, and it's wrong.
Justice Sotomayor?
General, this lack of conflict which your opposing colleague says doesn't exist. You mentioned a situation where it does. Why don't you succinctly state what they admit there's daylight Tell us exactly how you define where the daylight exists.
The daylight, as I see it, exists on two dimensions. They think that doctors can only provide stabilizing care when the woman is facing death. And we think, no, you can take into account things like kidney failure, the risk of a seizure, and lifelong neurological impacts based on that.
Well, they said the recent decision of the Oregon court says you don't need death to be imminent or immediate, I think is the word they used, if I'm not
So what the Idaho Supreme Court said in that decision is that there's no particular level of imminency and no certain % chance requirement, but what the court couldn't do is turn away from the language requiring the type of harm to exclusively be death, and also the inherent concept of necessity requiring some degree of imminence. It's true that it's a subjective standard under Idaho law, and the court made that clear, but what the Idaho Supreme Court also said is prosecutors are free to come in and have other medical experts second-guess doctors' decisions by saying, maybe you didn't subjectively think she really needed it as necessary to prevent death because, look, her sac had ruptured, but she wasn't yet infected. And that's exactly the kind of situation that leads to women being driven out of state, dumped on neighboring states by Idaho, and criminalizing the care, the essential care that they need.
Thank you.
Justice Kagan?
Yeah, if you could just talk a little bit about that, because as I understood it, for example, I read recently that the hospital that has the greatest emergency room services in Idaho has just in the few months that this has been in place, had to airlift 6 pregnant women to neighboring states, whereas in the prior year, they did 1, the entire year. So if Mr. Turner is right about what the state is trying to convey to hospitals about when they'll be prosecuted, like, why is this happening?
I think that the reason this is happening is because those doctors can look at the text of the statute itself. They can look at the Idaho Supreme Court's decision, which made clear, very clear, that this was a departure from prior Idaho laws that tracked EMTALA, and they can recognize that their livelihood is on the line, their medical license, their ability to practice medicine, their freedom if they have to go to jail and serve one of these minimum 2-year sentences of imprisonment, and they simply cannot provide the care even consistent with their subjective medical judgment, because as a matter of medical reality, for many of these conditions, it's not yet putting a woman at the brink of death or necessary to prevent her death, yet they know that the standard of care is to provide her with termination, because she is just going to get worse and worse and worse if they wait it out. And the other important point about this, and I think it goes back to this dual stabilization idea, is that tragically, in many of these cases, the pregnancy is lost. There's not going to be any way to save that fetus, because a woman who has PPROM at 17 weeks, there is no medical way to sustain the pregnancy to give the fetus a chance. So in that situation, what Idaho is doing is waiting for women to wait and deteriorate and suffer the lifelong health consequences with no possible upside for the fetus. It just stacks tragedy upon tragedy.
And it can't be the appropriate, you know, it's become transfer is the appropriate standard of care in Idaho, but it can't be the right standard of care to force somebody onto a helicopter.
And it's entirely inconsistent with what Congress was trying to do in the statute. You know, one of the primary motivators here was to prevent patient dumping. The idea was we don't want people to have to go somewhere else to get their care. You go to the first emergency room in your state and they have to treat you and stabilize you. But this effectively allows states to take any particular treatment they don't want their hospitals to provide and dump those patients out of state. And you can imagine what would happen if every state started to take this approach.
A question on the spending clause questions that you've been asked. I mean, what would, if you accepted some of these theories, what would the consequences of something like that be that we would have to worry about?
I think that it would call into question any number of federal spending statutes that provide funds to private parties, and there are a bunch of them. You know, there's the Medicare system itself, which is, of course, a major federal spending program. There are funds provided under Title VI, under Title IX, a lot of federal statutes out there that give funds to private parties and insist on conditions of compliance with the federal funding restrictions. And if the court were to suddenly say that can't preempt contrary state law, then I think that it would seriously interfere with the ability of the federal government to get its benefit of the bargain in those spending programs.
And you mentioned before that this question has never been a part of this case?
That's right. They did not make these arguments in the lower court. They briefly referred to the spending clause, but I don't understand them to have pressed this argument specifically. And so I think that the lower courts did not address it. I think the district court said in a footnote, they briefly referred to it in a footnote of their brief, and it's essentially waived.
Thank you.
Justice Kavanaugh?
You've touched on what's happening on the ground, and that's an important consideration and answer to the question of what's happening. But Idaho is representing, and I just want to get your answer on this, that, as I counted, 9 conditions that have been identified by the government where EMTALA would require that an abortion be available. An abortion is available under Idaho law, and that's in the reply brief. Now, are there other conditions? You've ruled out mental health. Are there other conditions you would identify, or are you just saying that that's not really happening on the ground? I think that's part of your answer, but I just want to get a fuller answer on that.
It certainly isn't happening on the ground. These are the conditions that we're worried about. And I think the problem with my friend's theory that Idaho law would permit it is that you just can't square it with the text of the statute. You know,
what
state
if
of Idaho is.
Keep going.
Well, I just wanted to say they're not the ultimate authority on what the Idaho law means. That's the Idaho Supreme Court, of course, and it has addressed this issue in the Planned Parenthood case. And I think it's really significant that in Planned Parenthood, the Idaho Supreme Court expressly contrasted this statute with other statutes that contain health-preserving measures and recognized this was a total departure from that. The legislature wanted to focus exclusively and more narrowly on a necessary to prevent death exception. So I think that essentially means that the Supreme Court of Idaho has already touched on this issue, and it's no wonder then that doctors who are facing these kinds of pregnancy complications where in their medical judgment it's not necessary to prevent death yet, but the woman is going to suffer serious health consequences, their hands are tied and they can't provide that care under the Idaho law.
If what's on page 8 and 9 of the reply brief were Idaho law, would there be a problem still?
So if we had an authoritative Idaho Supreme Court decision that said Idaho law allows for termination in the circumstances where EMTALA would require it, yes, of course, then the conflict goes away. But I can't imagine the court would say that because, of course, here. That's
not quite what 8 and 9 say, but I take your point on that. Separate question, different category. I think one of the themes on the other side is that this law passed in 1986 was a very important law addressing a very important problem, namely the problem where hospitals were turning away poor and uninsured patients who came in for emergency care. And the idea was that can't happen. We can't allow hospitals in this country to turn away poor and uninsured people in emergencies. But their theme is that the law was not designed contextually to deal with abortion or other specific kinds of care. And so they make a textual argument, but I think they also make a broader contextual argument about the whole idea of what was going on in 1986. I want to make sure, I don't think that's really come up too much. I want to make sure you respond to that.
I appreciate having the chance to address that. So at the outset, I don't think they can square that theory with the text of the statute, which says in no uncertain terms, here is the fundamental guarantee. If you have an emergency medical condition and you go to an ER in this country, they have to stabilize you. They have to give you such treatment as may be necessary within reasonable medical probability to ensure that you don't deteriorate. And yes, Congress did not provide a reticulated list of all possible emergency medical conditions and all possible treatments, but it was very clear that Congress set a baseline national standard of care to ensure that no matter where you live in this country, you can't be declined service and the urgent needs of your medical condition addressed. And, it would be no different if the state had come out and decided to ban epinephrine. That's the singular way to treat anaphylaxis, a severe allergic reaction. That would violate the statute, and we would be up here making exactly the same arguments because Congress didn't want that. If you have anaphylaxis and you go to an ER anywhere around this country, they're going to give you epinephrine, and Congress mandated that. And I don't see any way to try to draw lines around to exclude pregnancy complications in the very narrow but tragic circumstances where the only way to address the woman's condition and prevent material deterioration is for the pregnancy to end.
Thank you.
Justice Barrett?
So, General, I understand the primary difference between EMTALA and the Idaho statute to be this health, that Idaho focuses on the risk of life, but the federal government says that EMTALA says that the health is, am I right? It's health and life?
That's the principal difference, but I think that's also the difference between necessary to prevent death versus the health concerns would be reasonably expected to occur. So I think that is a standard that builds in a little more space for doctors to take action.
Got it. Is the federal government aware of any state other than Idaho that has a law that does not take health into account?
There are 6 other states that have severe abortion restrictions without a health exception. So I think that those are the primary category of states we're concerned about here.
Thank you.
I should make clear that there are some pending judicial challenges in those states, and so their laws are not always enforceable or in effect right now.
Besides Texas, has the federal government brought suits similar to the one brought in Idaho and Texas and any of these other states?
To be clear, Texas was not our affirmative litigation. They sued us, but we have not brought affirmative litigation in other states. And I think this case has been on a course, and Idaho's law was particularly severe because at the point at which we sued, it seemed to cover ectopic pregnancy, and the state conceded that. Now, they have modified the law to exclude that, but it was one of the most pressing concerns because of that.
Thank you.
Justice Jackson?
General, petitioner relies pretty heavily on clear statement rule principles, and I wonder whether you might comment on my thought that those principles actually cut against them in this case. As you said, Congress set a baseline national standard of care. It has said in no uncertain terms that the hospital must provide stabilizing care to people experiencing emergency medical conditions. There was no, as you've said, particular conditions or particular treatments talked about, carved out, et cetera. So if a clear statement is required, wouldn't it be the requirement of exempting abortion? I mean, Justice Alito has talked about some of the references to unborn child, but none of them read like an exemption that I would think our clear statement rule would require in a circumstance in which the baseline is this clear national standard of care.
Yes, I agree. I think that Congress clearly was requiring stabilization and made that an unqualified mandate. It wasn't exempting particular conditions or particular type of treatments. And, this court has said that there's no canon of donut holes. That was in Bostock, that when you have a provision like that, the fact that you don't have a specific enumeration of one of its applications doesn't mean that you should read in some kind of implicit exception. So I think
if we're looking for something clear, we would need to see, I would think, the clear statement that Congress meant for you not to have to provide an abortion pursuant to the mandate of providing stabilizing care.
Yes, and I think it's important to recognize that every relevant actor has understood the statute this way from the beginning. They understood Congress's clear mandate here. This has been the agency's position all along. We are not adopting a new position. That's reflected in our enforcement activity and in HHS's guidance and rulemakings in this area. Providers have understood it, even those hospitals that don't provide elective abortions. They have always provided life-sustaining and health-sustaining pregnancy termination consistent with EMTALA. Congress itself recognized it in the Affordable Care Act, and I don't think there's any reasonable argument to be made that people misunderstood what Congress was doing in the statute.
Thank you.
Thank you, counsel. Rebuttal, Mr. Turner?
Thank you, Your Honors. EMTALA takes state law practice of medicine standards as it finds them. As Justice Gorsuch noted, that's what Section 1395 says. And in fact, in the vaccine mandate case that was referenced, that's what the Solicitor General's office told this court when it said that 1395 does not allow federal officials to dictate particular treatments for particular cases. That's exactly what they are trying to do here with EMTALA. It's also confirmed by subdivision F. That codifies a presumption against preemption. And so to Justice Jackson's colloquy at the end, that is the point. You do presume that state law continues to operate alongside EMTALA. You don't presume the opposite. It's supported by the CMS Operations Manual, which is HHS's Rosetta Stone of EMTALA enforcement. It tells doctors, it tells CMS enforcement agents on the ground that you consider what is available by referencing what is within the scope of that doctor's license. That is exactly what we are saying. It is also specifically directed in 42 CFR 489.11, which requires hospitals to assure that their medical staff comply with state law. That's a federal regulation that directs hospitals to require their hospital staff to comply with state law. It's also confirmed by the 115,000 enforcement instances that totally lack any theory that would support, any case history that would support the administration's reading. She says that this has always been understood to be the case. Well, you'd think that we would find in those 115,000 instances a single example where state law was overridden by EMTALA, and there isn't one. And finally, the text. The text qualifies EMTALA's stabilization requirement by the staff that is available. We know nurses can't perform open heart surgery, and we know janitors can't draw blood. It's not just a plain mandate devoid of reference to state law. And we know the word available, even in a common usage, incorporates state law. For example, you heard just the other day that when considering whether a bed is available for homeless people, it has both a physical sense and a legal sense. And whether cigarettes or alcohol are available to people in Idaho, there is both a physical question and a legal question. Opioids are available in hospitals. They are on the shelf. They are physically there. But there is a legal question that comes into play too. It is the same with abortions. In response to the Chief Justice's question on conscience, General Prelogar said that both hospitals and doctors are exempt from EMTALA's supposed abortion mandate. We're relieved to hear that, but I think that it highlights the utter inconsistency of the administration's reading. So if EMTALA's stabilization requirement is general enough not to override extra textual protections like conscience protections, then it cannot be so specific and include a requirement that is in direct conflict with state law. Those two don't jibe. This court does not lightly find a direct conflict. Congress must speak clearly. It has not done so here. The administration's position ultimately is untethered from any limiting principle. I think we heard that. There's just no way to limit this to abortion. And there's no way to limit it to Idaho. There are 22 states with abortion laws on the books. This isn't going to end with Idaho. It's not going to end with the 6 states that General Prelogar mentioned, because all of the states that have abortion regulations define the health and the emergency exception narrower than EMTALA does. And so this question is going to come up in state after state after state. It's also not limited to physical health. I know General Prelogar says that there's no circumstance in which a mental health condition would require stabilization with an abortion. But now she's just fighting with the American Psychiatric Association, the very standards that she's setting up to say controls the EMTALA inquiry. That's not consistent. And it isn't limited to EMTALA. Justice Thomas, Alito, Justice Gorsuch, you all pointed out the major spending clause implications that are at play here. And I disagree that we didn't brief this. It's on pages 20 to 21 of our opening brief. We recognize that this is hugely concerning if the federal government can pay private actors to violate state laws, and not just any state laws, state criminal laws. The implications of that are vast. It leaves the federal government unbound by enumerated powers. And I think General Prelogar admitted that. The court doesn't have to answer that question on our reading. It does on theirs.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until tomorrow at 10 o'clock.